You are listening to the NPZ Law Firm Show. Immigration woes, visa serve nos. US and Canadian immigration and nationality lawyers who speak your language.
Back on the Immigration Hour of the NPZ Law Group, simplifying immigration for you and me. I'm Vijaya talking to Snehal Batra, Managing Attorney at NPZ Law, and she's at their Raritan office. Snehal, welcome.
Hi, namaste, કેમ છો?
Kem cho, tame kem cho, and good to have you. And of course, so Snehal, I was wondering what happens when a US petitioner dies? What is the process then?
Right. So Vijaya, upon the death of the petitioner who's filing the relative petition, the I-130 is automatically revoked. Okay, so the Immigration Service revokes the I-130. So what happens there is the family, the beneficiary that's left in India, they're unable to immigrate. Okay, so unfortunately, over the past several years, we're seeing more and more of these types of tragedies, specifically for our Indian clients, because this is due to the fact that the backlogs are so lengthy, right? Mm-hmm. So for example, a U.S. citizen filing for a married son or daughter, or a U.S. citizen filing for a sibling, the wait time is 15 years or more in some of these cases.
Wow.
So yeah, and a lot can happen during that time. Mm-hmm. Of course, during the past few years with the impact of COVID, unfortunately, in some cases, the petitioner dies. So what happens when the petitioner has died and the family is still waiting in India, for their priority date to become current? Mm-hmm. So under the law, under the immigration law, the Immigration Service can exercise discretion and reinstate that approved I-130. And this is called the Humanitarian Reinstatement. Now, it's really important to know that the Humanitarian Reinstatement can only be requested if the I-130 is approved before the petitioner dies. Okay, uh-huh. So in that case, then what happens is the beneficiary, the family members that are waiting in India, can request the Immigration Service to reinstate the I-130. They have to make a request. There is no form or filing fee. It's basically a written request proving that the petitioner has died, proving mm-hmm. the evidence with the death certificate, proving that the I-130 was in fact approved, okay? And then two basic requirements. One is a substitute sponsor for the affidavit of support, because most immediate relatives and family-based petitions require the form I-864. And we talked about the affidavit of support a couple shows ago.
Yes.
So first we need a substitute sponsor, and it can't be anybody. It can't be like, oh, I have a family friend, they're gonna take over, okay? The key here is that the substitute sponsor must be your spouse, parent, mother-in-law, father-in-law, sibling, child, son or daughter, son-in-law. So there are very specific individuals that would qualify as a substitute sponsor. Mm-hmm. In addition, they would have to complete the form I-864. Okay, that's one requirement. The second requirement for the humanitarian reinstatement are the factors, because it is a discretionary benefit. It means the Immigration Service is going to look at all of the positive factors against the negative factors and decide whether or not, based on a humanitarian reason, this I-130 should be reinstated, okay? And so what we like to discuss is the impact on the family that's in the U.S., especially if they're U.S. citizens, green card holders. We like to create a list of these family members and show that, there are other relatives in the U.S. and therefore the family that's left in India should be granted the reinstatement based on this factor. Also, if there's any kind of medical issues or advanced age or health concerns of the beneficiary, the person that's still waiting in India, ties to their home country or lack of ties, if everybody in their family is now immigrated to the U.S. and they are basically left behind, mm-hmm. okay? So we're kind of like pulling at their heartstrings, why should this family be allowed to immigrate? Mm-hmm. So they basically, it's an exercise of discretion. They're going to weigh all of the factors for the reinstatement, okay? Mm-hmm. And so The unfortunate thing is that this is a very long process, okay? There is no 6 months or 12, it could be a year, it could be longer. Most cases it's 2 years. And if the I-130 is reinstated, then the immigration will go ahead and continue the green card processing.
Mm-hmm.
So there is a possibility in these cases where the petitioner has died.
Mm-hmm. Wow, that's good to know that there is light at the end of the tunnel for folks back waiting there. So thank you for that, Snehal. And the road to immigration, US or Canadian, can be long and arduous. So you want the best advocate rooting for you and helping you through. And that's NPZ Law Group. You can visit them at visaserve.com or call them at 201-670-0006. And don't forget to mention Mirchi for that special discount on your consult. Well, more in-depth insights on immigration law with the NPZ Law Group attorneys coming up in just